Welcome to everyone. Today, I am going to talk about USCIS Implements Risk-Based Approach for Conditional Permanent Resident Interviews. United States Citizenship and Immigration Services April 7 announced a policy update to adopt a risk-based approach when waiving interviews for conditional permanent resident CPR who have filed a petition to remove the conditions on their permanent resident status. Effective immediately, new criteria will guide USCIS officers on when to waive interviews for CPRs who filed a Form I-751 petition to remove conditions on residence. This update replaces previous agency guidance that required all CPRs to undergo an interview if they obtained CPR status via consular processing. Implementing a risk-based strategic approach to the CPR interview process will increase efficiencies that improve processing times, allow for better use of agency staffing resources, and help reduce the pending caseload while still maintaining procedures to identify fraud and protect national security, said USCIS Director Ur M. Jaddou. This update is consistent with agency priorities to break down barriers in the immigration system, eliminate undue burdens on those seeking benefits, and effectively respond to stakeholder feedback and public concerns. The prior policy requiring mandatory CPR interviews did not prove to be an efficient use of USCIS staffing resources. Under this policy update, USCIS may waive the interview requirement if the agency officer determines there is sufficient evidence about the bona fides of the marriage. The joint filing requirement is eligible for a waiver if applicable. There is no indication of fraud or misrepresentation in supporting documents, there are no complex facts or issues to resolve, and there is no criminal history that would render the CPR removable. A non-citizen who obtains permanent resident status based on a marriage that began less than 2 years before obtaining that status receives permanent resident status on a conditional basis for 2 years. To remove the conditions on permanent resident status, family-based CPRs generally must file a Form I-751 within the 90-day period before the 2-year anniversary of when they obtained CPR status. In the end, I would like to ask you, like the video and consider subscribing the YouTube channel. Thank you.